What is a physician statement and why is it important? A physician statement is a document that a court can use in a child support claim to assess or determine whether or not somebody is unable to work because of a disability. Hi, I'm Alicia Kinchel, the owner of Kinchel Law, a family law firm based out of the Philadelphia area. Oftentimes, when we have child support cases or spousal support cases, and one party is arguing that they're not able to work because of a disability, the court may require them, and usually do require them, to produce a physician statement. And this is the form that is supposed to be filled out by the parties treating medical professional that can discuss the time frame of the disability, why they're disabled, and whether or not they're able to work. Now, generally, most places will require it. Where we don't often see it is where there's already been a finding of determination by Social Security. And that's because the courts will look at the process by which Social Security will determine whether someone or not someone's disabled to be a much more vigorous standard than the court can do, just from time, access to information, and the person who is trained to be able to determine whether someone can work. The court will usually take those statements or that finding and use that. We'll see that they'll use that often when there has been a finding of disability. So, in an SSI case or a Social Security disability insurance case, or even in a situation where a person has been determined to be medically disabled but may not meet the other eligibility rules. And that can be because for SSI, maybe there's too much household income in the house, or maybe because they didn't have enough credits on the other side. But they usually will use that. Now, where a person is maybe one, still going through the process, two, is collecting short term disability benefits or long term disability benefits, or maybe out of work right now because of workers' compensation, the court can look to that statement. Now, one thing that people often don't know is that the person who's on the other side of the case can challenge that statement. And especially if it's done at the beginning process, so that's where you're going to have your conference, you can object to it, and that can require the doctor who completed that form to come in and testify. You may also end up being responsible for how much it costs to bring that professional in to provide that testimony. So it's important to understand what your rights are, one, as a person who is claiming to have a disability and be unable to work because of an injury or illness, and also being on the other side of that, where you are the person who may be receiving the child support, even a person who's paying child support, but just want the correct amount to be used in the support calculations when it comes to the other party's ability to work or their earning capacity. It's important to note that there are some other things that are considered. And again, whether SSI or SSDI benefits count as income, they don't for SSI, they do for SSDI. How additional income might affect the total income or overall income for the party who's claiming disability. So if you are working under the table and the person can prove it, or if there is income that you have by working, which you can still actually work while you collect some disability benefits up to a certain amount of hours or up to a certain amount of money and not lose your benefits. Those are all things the court can consider. And as always, you should understand that all of these things are just pieces of evidence that get weighed in the overall process. While, like I said before, that generally the courts may look to the finding of Social Security to determine whether or not somebody's disabled. But if there's other proof that weighs a little heavier, like you can prove the person is actually still working and maybe just haven't told Social Security they're not working, that they are working, those are things the court can use. So that's why it's important to speak with an attorney licensed in your state about the facts specific to your case, because you also understand that if you don't challenge or make certain arguments at certain places within your case, you may waive your right to bring those things up forever, potentially. So speak to an attorney. If you want to talk to us, our information is in the show notes. If you have any questions, please put it in the comments and like, share, and follow. Until next time, take care.